Hi, good morning, everyone. Welcome to our webinar on UK Director Compliance, Key Legal Obligations, and Company House ID Updates. So my name is Simon Reynolds. I'm one of the Senior Legal Solutions Consultants here at LegalVision, and we're very lucky to have Michaela Corley. She's our Senior Associate with the corporate side of legals. So yeah, perfect person to discuss all of these exciting bits. Cool. So before we get started, just a couple of housekeeping items. Just first and foremost, everyone will receive a recording and slides of this in email. So just keep your eye out for that. Secondly, please do not hesitate to submit questions throughout this webinar, just with regards to the Q&A box. We will answer as many questions as we can at the end of the webinar. And then just last but not least is please just take a couple of minutes to complete our feedback survey. After the webinar, we're always looking to improve, and any feedback is really appreciated. Awesome. So yeah, by viewing this webinar, you are eligible to receive a complimentary consultation with LegalVision just to discuss more specifically how we can support your business and what your legal requirements are moving forward. To claim your complimentary consultation, please just leave your details again in the survey, or please just pop your details through the contact us link through our website. You can always engage through that side of things too. Awesome. So I'm just going to pass on to Michaela. She's just going to run through our agenda and crack on from there. Thanks so much.
Thanks, Simon, and good morning, everyone. So today we'll be going through broadly a lot around directors' duties, as well as some of the changes that you might have seen with Companies House at the moment with ID verification. So we'll go through the role of a director just generally. I'll explain the Companies House updates first, just because I think they are quite important. Then we'll go through company directors' duties under the Companies Act, common law duties, other obligations that a director might have at law, and then broadly the consequences that there could be for breaching directors' duties. And then at the end, there'll be some time for a Q&A as well. So the first thing to go through is just generally around what the role of a director is. Now, in a company structure, you'll have directors, shareholders, and sometimes companies will also have a secretary. Now, whilst the company is a legal person, it does need people to actually act on its behalf, and that will generally be its directors. So normally the directors will be making the day-to-day decisions for the company. So that will include negotiating contracts on the company's behalf, signing agreements, enforcing rights against others. Now, directors can exercise all the powers of a company except any powers that either, say, the Companies Act, the shareholders agreement, or the company's articles of association require to be exercised by its members firstly. Now, members being the shareholders of a company. So that means that the directors will be responsible for managing a company day to day, dealing with its affairs. So as I said before, day-to-day decisions. So that could be anything around the company's accounts, work for the business, making sure reports are properly prepared, signing contracts, things like that. Some directors will also work in the business, and that is what we refer to as an executive director, whilst others will just attend board meetings, so director meetings, and contribute to decision making. And that's what we usually refer to as a non-executive director. Decisions they'll usually make, as I said, the day-to-day decisions. They could also be involved in the issuing of shares in the company, declaring and paying dividends, or authorizing the company to take out a loan, or for instance, give a loan. Now, in terms of directors' actual duties, they have duties three different ways, which we'll go through. The first is under the Companies Act. So there are 7 main directors' duties under the Act, which are known as the general duties, and I'll go through those shortly. Then there are what we call uncodified common law duties. So this is essentially just law that's developed over time through court cases, and it's what we also refer to as fiduciary duties. And then there can be other duties for directors under other pieces of legislation. So for instance, insolvency laws or health and safety laws might have certain obligations on directors as well. But before we get into that, I'll go through the Company House changes that you might have seen recently. Companies House has been putting these, whenever you log into your web filing account, they've also been sending out emails. So you might have already come across an article on these changes. But essentially, what the UK government is doing is it's introducing identity checks to ensure that individuals listed on Companies House are who they say they are. Now, the reason that they're introducing this, it's mainly to prevent any sort of fraud or misuse of company structures, but it's also to increase the trust in the information that is available on the register, ensure that the Companies House register is accurate, business records are accurate, and also just to connect people to their business entities so that there is that public record of that as well. So what that means is that from the 18th of November this year, so that's only a couple of weeks' time, identity verification will be required for certain individuals. Now, that at the moment is new directors and people with significant control. So that's what we call PSCs. So a PSC could be anyone with, say, 25% shareholding in a company, 25% voting rights, or it could just also be someone who has general control over the company as well by virtue of, say, control for certain decision-making under a shareholders agreement or something like that. So new directors and PSCs will be required to verify their identity, also existing directors and PSCs, and also someone who files for a company. So for instance, a company secretary would also need to verify. The verification requirements will also apply to individual directors of overseas companies with UK establishments as well. Verification for other people will be introduced at a later date, and Companies House is still in the process of confirming when that will be. So that would be for any corporate directors of companies, corporate members of LLPs, and officers of corporate PSCs. There are different requirements for when you actually need to verify from the 18th of November 2025, depending on who you are, but it is becoming mandatory for those individuals, although the deadline might be after the 18th of November, depending on your individual circumstances. It is still mandatory, so it's a good idea to just attend to it now so that you have your personal identification code and can use that going forward. But what I'll do is I'll just go through some of the timelines depending on who you are in a company. So the first is if you are an existing director who is also a PSC, your verification will need to be completed before the company's confirmation statement is due, because you'll then need to provide the code when you're filing that confirmation statement in your capacity as a director. Individuals, directors will then also need to provide the code to Companies House via a separate service in their capacity as a PSC within 14 days of the company's confirmation statement date. So essentially, you need to make sure you have that code before you go to lodge your confirmation statement if you are an existing director or a PSC. Then the next, or existing director who is also a PSC, sorry. The next is PSCs who are not company directors. So this is where you might say, for instance, hold shares, 25% of shares in a company, but not be a director. You'll have 14 days starting on the first day of your birthday month to provide Companies House with your personal code. So you should ensure that the verification is done well in advance of that date. So for instance, if your date of birth is January the 22nd, your 14-day period will begin on January the 1st. So it's a good idea to get it done now so it's ready, that you have the code ready for that before that 14-day period starts. The next is if you are incorporating a new company or appointing a new director or a new PSC who doesn't already have a code, the verification will need to be completed in advance of that incorporation appointment. Say if it's a share issue to a new PSC, that will need to be done before it can occur or before you can update Companies House. So for incorporations, the code needs to be provided with the application to incorporate the company. For appointments or PSC notifications, it needs to be provided with the filing to Companies House. If you become a PSC after the 18th of November 2025, you also need to provide your personal code within 14 days of being added to the Companies House register. So there's lots of different moving parts depending on who you are. But it's a good idea just to get that process started now, even if you are thinking about incorporating a new company, or if you are already a director of a company, it's a good idea to do that now so that you're ready to and have that code when you need it. Now, the next thing to talk about is how to verify your identity. So there are 3 options that are available. The first is you can actually verify directly with Companies House via your gov.uk one login. That option, though, is only available if you have a certain type of photo ID, and that photo ID would need to be a biometric passport from any country, a UK photo driving license, a UK biometric residence permit, so a BRP, a UK biometric residence card, BRC, or a UK frontier worker permit. So you'd need one of those photo ID types. You would then also need your current address and the year that you moved in order to verify through gov.uk one login. The other option is to verify your identity at the post office if you meet certain eligibility criteria. And then the third option, which we're finding a lot of clients are opting or wanting to use from the 18th of November, is to use an authorised corporate service provider, an ACSP, to verify your identity with Companies House on your behalf. Now, LegalVision will be an ACSP provider, or is an ACSP provider, and from 18th of November, we can assist with verifying identities with Companies House as well. What happens if you don't comply with these deadlines? So I actually think this is one of the questions that was asked before the webinar. Now, if you don't complete the identity verification, you will essentially be unable to do things that you need your code to be able to do as a director or PSC. So for instance, if you want to start a new company, you wouldn't be able to incorporate without your code. If you want to submit filings to Companies House, and there are deadlines for when filings need to be submitted by, you also wouldn't be able to do that. You could also, though, be committing an offence. So directors and PSCs who continue in their roles without verifying may face fines, disqualifications, or disqualification or other legal consequences. So it's a good idea to get it sorted. But essentially, you wouldn't be able to submit filings to Companies House without getting that code. So for instance, if you were going to lodge the company's confirmation statement, you would need the code. If you didn't have the code, you wouldn't be able to lodge the confirmation statement. That could then lead to the company being struck off because you'd be unable to submit the confirmation statement. So it's a good idea to get it sorted now so that you're ready with that code to go forward with that. Okay, so that's the Companies House updates and the identification requirements. Now we'll go back into more around directors' duties and what those duties entail. So the first type of duties is what we call general duties. Now, these are the duties that are set out under the Companies Act, and there are 7 main general duties set out under the Companies Act. Where there is more than one general duty in a situation, the directors must comply with each applicable duty. So more than one duty could apply in any sort of scenario. The first duty that we'll go through is the duty to act within your powers. Now, the power of a director comes from the company's constitution. So the constitution being the rules set out in the company's articles of association, any shareholders agreement, if there is one, or any powers provided under the Companies Act itself. There could also be powers that are passed under resolutions and agreements by the company's shareholders and directors that also affect the company's articles of association. So the duty to act within your power does require that you only act within the scope of powers given to you by those documents that I've mentioned in the Companies Act. So for instance, suppose that the company's articles of association require that you seek shareholder approval to appoint a new director. If a director appoints another director without seeking shareholder approval, that could be a breach of this duty. The next duty is the duty to promote the success of the company. Now, this is actually one of the more controversial duties because it's quite interesting how it works. So it states that as a director, for every decision that you make, you must act in such a way that promotes the company's success for the benefit of all the shareholders. Now, whilst you would be promoting it for the company's success for the benefit of all the shareholders, whilst doing that, you need to also have regard to other considerations, which you'll see on your screen at the moment. Now, those considerations would be any long-term consequences, interests of company employees, interests of your company's business relationships, so suppliers, customers, any impact on the environment and the community, or impact on the reputation of the company. And you also have a requirement that you need to act fairly amongst all company shareholders. So essentially, the law will require you to consider more than just maximizing the company profits at the expense of all else. Now, whilst not every decision will need you to consider every single factor, you will need to demonstrate that you've considered the relevant factors before acting. But it's also important to keep in mind that the overriding interest in all of this will be to the members, so that the shareholders as a whole. Practically, what this means is anytime you or the other directors prepare to make a decision, you should be asking if such decision would be reasonably relate to the specified factors in the Companies Act. If so, you then would need to document the fact that you've considered the relevant factors and document any discussions that you've had around those relevant factors. What we tend to see as well is it's usually good practice for any sort of board minutes or board resolution to state that the directors have taken the factors outlined in Section 172 of the Companies Act, which is the duty to promote the success of the company requirement, into account when they're reaching their decision as well, which is why you'll often see that in board resolutions. The next duty is the duty to exercise independent judgment. So as a director, you need to exercise your judgment and act alone. Now, that duty will require you to always act independently and not under the influence of a third party. Practically, that actually might be quite difficult, particularly where, as a director, you're relying on the advice of a third party. So, for instance, an accountant or consultant in those roles. But as long as you, even though if you're taking into account that advice from the accountant or consultant, as long as you exercise your own independent judgment when evaluating that advice, you wouldn't be in breach of this duty. The next duty is, so the fourth duty is the duty to exercise reasonable care, skill, and diligence. So it essentially requires directors to act with a degree of competence. Now, it actually has two elements, the first being the objective standard and the second being the subjective standard. So with the objective standard, that is just basically the general knowledge, skill, and experience that one would reasonably expect of any director. Whereas with the subjective standard, that would actually encompass any particular expertise or skills you might have. So for instance, if you're an accountant, that might be taken into account. So all directors must act as would any reasonable director. So if, for instance, in the scenario that you fail to deliver your accounts to Companies House, that could be a breach of the duty to exercise reasonable care, skill, and diligence, because you would have fallen below the standard one could expect of all directors, so the objective standard. Whereas in that same sort of scenario, if, say, for instance, you have the skills of an accountant and you fail to disclose, say, a particular piece of information that you ought to have known because of your accounting experience, you might actually be held to a higher standard given that, and therefore you could be in breach of this duty, where a director who is not an accountant might not have breached this duty in the same situation. So an example case here is actually Dorchester Finance Co. v. Stebbing, which is quite interesting. It was actually a claim by the company against two of its directors who were qualified chartered accountants. The directors would often sign checks in blank at the request of another director to later be filled in. The court found that the directors had to actually act in good faith and in the interests of the company and display, under this duty, such skill as would reasonably be expected of persons with their knowledge and experience. Now, essentially, in this case, the court found that the directors had been negligent and would be held to be in breach of their duties. The fact that they were accountants as well contributed to that, because they should have known better than to sign unblanked checks. Now, the next duty is the duty to avoid conflicts of interest. So this one actually comes up probably, is one of the most common duties that comes up. So as a director, you must avoid situations that create conflicts of interest with the company's interests. Now, it applies in particular with the exploitation of any property, information, or opportunity that the company has, regardless of whether or not the company could take advantage of the same. I guess, just to explain it, there is an interesting case, which is Industrial Development Consultants versus Corley, which was where a managing director had been negotiating to design and build depots for a third party. The negotiations were unsuccessful with the company that they were a director of. That managing director then resigned, and subsequently, but only after their directorship had ended, secured the contract for himself. Although the proposal, whilst he was a director, had actually been elicited during the course of his employment and his directorship. In this case, the court actually concluded that the director had put himself in a position where his own private interests conflicted with the interests of the company that they were a director of. They then ordered him to account to the former company they were a director of for profits which he had made now and will make as a result of him having the interest and breaching his duty to conflict. So it's an interesting one. It does come up quite often, as you can imagine, if people are directors of more than one company, if they've got their own personal service company. So as a director, you can seek the authorization of the other directors, provided they are independent and have no interest in the situation as well. If the directors authorize your action, then there would be no breach of this duty, provided they have all the information they need to make the decision about waiving basically the conflict of interest. The director with the conflict also cannot vote on the matter. So if the quorum requires that director's vote, it wouldn't be able to go ahead. You would also need to make sure you're looking at the company's articles of association and shareholders agreement. There could be other requirements in those documents to seek authorization for the conflict. So for instance, it might require shareholders to approve any conflict as well. Now, the next duty is the duty to accept benefits from third parties. This one is probably just, it's well explained by probably an example. So for instance, if you're an electrician, you visit a job as a company director to speak with a potential client and secure a contract for the company that you're a director of. But after talking with the potential client, they then turn the company offer down, but then approach you and offer you the same contract in your personal capacity. Now, if you accept that contract in your personal capacity, you could be in breach of that duty. So the duty not to accept benefits from third parties, because it's a benefit that you actually obtained in your office as a director of the company. This scenario also could be a breach of the conflicts of interest duty as well, because there's a conflict of interest there. So that's one to keep in mind. The next one is the duty to declare an interest in transactions with the company. Sort of intertwines with the other one and with conflicts of interest, but if you have an interest in any transaction, you essentially need to declare it to the other directors. If you don't, you'll be in breach of this duty as well. So this duty applies to situations where you might also not have a direct interest in the transaction. So for instance, if your brother is selling a piece of land to your business, that is an indirect interest, but you still need to declare it because it is your brother and you could have a potential interest in it. So that is the general duties under the Companies Act. There are also some additional common law duties that aren't covered in the Companies Act. Now, the basis of these duties, as I said before at the start, is they've basically developed over time through court cases. They are on the fiduciary relationship between the director and the company, so what we call fiduciary duties. What that means is a fiduciary is expected to act in the interests of another. So in this situation, there is a fiduciary duty, the director, to act in the interest of the company. Now, some major common law directors' duties. So you'll see some of them on your screen. But the first is a duty to inform themselves of the company's affairs. So this could be to join with co-directors in supervising and controlling them, duty to maintain a sufficient knowledge and understanding of the company's business, enable them to properly discharge their duties as a director. So basically have an understanding of what's occurring in the company, have an understanding of what contracts there are, the accounts, being across company information, essentially. The next is a duty of confidence. So a person who receives information from another party in confidence cannot take advantage of it. So if you're aware of confidential information, so client lists for the company you're a director of, you cannot then go and use that information elsewhere for your own benefit. There's obviously other things that you'd factor in there around GDPR and things, but that's more around the duty of confidence. Now, the next one is interesting. It's a duty to disclose wrongdoing. It's actually more recently that this has come up and been developed in the courts, and it's basically a subset of a fiduciary duty. So in terms of the duty, it's a duty to disclose one's own wrongdoing or that of another person insofar as it affects the company. Now, to explain this, there's actually an interesting case. So Software UK Limited, Item Software UK Limited versus Fasihi. So this is where a director had basically the conduct of negotiations to renew a distribution agreement for the company. They, as part of those negotiations, encouraged the company they were the director of to adopt an aggressive stance in the negotiations, while simultaneously also suggesting to the other party the distribution agreement was with that they could set up their own company to take over the agreement. Now, the Court of Appeal actually concluded that the director did owe a fiduciary duty to disclose his own wrongdoing by obviously a breach of the director's duties there, and also that he had breached the general duty to act in good faith in the best interests of the company, which is one of the duties that we were talking about before as well. Now, in addition to common law duties and the general duties under the Companies Act, there could be other pieces of legislation that apply to both the company, but also to the directors as well. So, for example, a director could be held personally liable for breaches under the work health safety laws. So this is where laws that require companies and the directors to ensure that the company is operating safe working practices, environmental, chemical regimes, for instance. There's also anti-bribery legislation that actually imposes potential criminal penalties on companies and their directors if they engage in bribery or corruption. Any breach of financial services laws where it can be shown that the director was involved in the breach and had knowledge of the breach, that they could also be personally liable for. I guess one thing to keep in mind is a director may also be employed by the company. And in those situations, whilst it's not really a direct director duty, they could also be breaches of an employment contract that they've got. So if there's conduct issues, there could be inadvertently breaches of an employment agreement as well. Other ones, I think on your screen as well, is anyone accused of discrimination, whether that's a director or otherwise, could be pursued under the Equality Act. And then there's also just general statutory duties around ensuring the company meets its filing requirements. So, for instance, with Companies House, files its confirmation statements on time, annual accounts, updates any company information with Companies House within the required timeframes, things like that. Other matters that directors would be expected to do, all of which actually help to assist to you in remaining in compliance with your director's duties. The first one is a big one. So making sure you're diligently keeping record of any minutes, resolutions, books, accounts. So essentially just maintaining good corporate governance. The other is maintaining the company's statutory registers. So this is where the registers that are required under the Companies Act for a company to maintain. So that's your share registers, options register, directors register, PSC register, those sorts of things. Also being familiar with your company's state of affairs, so financial reporting, auditing, your accounts, being familiar with those sorts of things. Depending on the size of the company as well, there could be additional reporting obligations from a financial perspective as well. Making full and frank disclosures of any conflicts, potential conflicts, that's a good one to avoid the conflicts of interest duty. Then regularly holding directors' meetings to ensure good corporate governance. That would also mean that you'd be needing to make sure that you're also holding annual general meetings of the shareholders as well, but also ensuring that any meeting is held in accordance with the articles and the shareholders' agreement. Also with directors' meetings, you'd be wanting to make sure that you're voting in accordance with any requirements under the Companies Act, articles, shareholders' agreement. So just overall ensuring that there is good corporate governance in the company. So what are the consequences if you do breach your general duties and other duties or obligations under the Companies Act? So there could be consequences. There could be civil penalties imposed. So that's personal liability for losses caused, disqualification as a director. And in some circumstances, there can also be criminal penalties. So fines, imprisonment, and that's probably more in more serious cases. It will depend on what duty you are breaching and the fallout from the breach. So, for instance, if you make any personal profit in breaching a duty, a court could order you to repay the amount that you've made in terms of the profit. If you cause the company any loss in the course of breaching the duty, a court could order you to compensate the company for that loss. If you take company property, you would have to return it. If you plan to breach your duty, so for instance, if you try to enter into competition against the company, the court could then issue an injunction being an order not to do something, so to not breach that duty. And then in terms of fiduciary and general duties owed to the company, shareholders and third parties will not normally have a direct cause of action for those fiduciary and general duties against individual directors. The company will normally be the one to claim against you. But in certain circumstances, members, so shareholders, may be able to bring what's called a derivative claim on the company's behalf, which is a power that's given to them under the Companies Act. And then in terms of any third parties, liquidators could apply under what's called a misfeasance procedure for the court to examine the conduct of the directors and potentially order them to make a repayment or contributions to the company's assets if there has been a breach of their duty. That will normally come up in liquidation proceedings if the company is in the process of being liquidated. A breach of the duties could also lead to, say, for instance, a breach of your director services agreement if there is a separate contract that you have with the company as well, and that could be a direct claim that the company has against you. It could also lead to your removal as a director from the office. That could be an ability of the company under either the articles for the company or a shareholders agreement. And it could lead to disqualification as well, which is usually under what we call, the piece of legislation is the Company Directors Disqualification Act, that you could be disqualified under as well. So I'll hand back over to Simon now.
Amazing. Thank you so much, Michaela. That was, super informative. And that concludes the main part of our webinar, everyone. You might obviously find this publication incredibly useful. Please take some time to download it. You can also find a lot of publications and just general resources on our website, but this is specific around corporate governance guide for SMEs in the UK. So yeah, definitely something to check out. And you obviously also might be interested in our upcoming webinar, which is Demystifying M&A, Mergers and Acquisitions, what every business owner should know. So this is going to be held on Tuesday, the 9th of December at 11 a.m. Obviously, if you're interested, please do not hesitate to just register through the link there on your screen. Great. So yeah, just wanted to spend a minute or so just talking about how we operate as a legal firm. So traditional, law firms typically operate on an hourly rate or operate on a fixed fee basis. And yeah, things can add up really, really quickly. Things can get incredibly expensive. We offer what's called a legal membership model. So a good 90+% of the clients that we work with love working with us specifically on this model. So instead of having uncertain, costs when it comes to legals and, having things add up really, really, really quickly, our membership is a fixed monthly cost, and you're literally getting unlimited commercial legal support. So we've got over 140 specialist lawyers across, Australia, New Zealand, and the UK. Obviously, we focused here on UK jurisdiction, but it gives you unlimited access to document drafting, reviews, amendments, unlimited advice and trademark applications, everything else, from corporate and commercial, mergers and acquisitions, capital raising, litigation. We also do a lot of support around employment, subcontractors, GDPR, you name it, intellectual property. We're a one-stop shop for all of those things. So we like to set up our clients on that model. It's typically incredibly cost effective, and it allows you to get some seriously good value depending on all of the different requirements that you have. So I would just really recommend to get this free complimentary consultation, as mentioned, to drop your details through. But then we can really discuss the more specific requirements that your business has. Obviously, we deal with all types of organizations, what your pain points are, what legal areas are your biggest challenges, just to really kind of, pull back any kind of layers around that. And we can discuss how we could best support your business. We also do have different pricing options, which you can see on our website. They start at around £115 a week, obviously upwards depending on the requirements and the organization that we're working with. Cool. So yeah, we're gonna obviously just pass back to Michaela shortly, just to answer any questions that everyone might have. You might also just see the poll pop up on your screen. So please take some time. We would really appreciate if you answer that. But yeah, back to you, Michaela.
Thanks, Simon. So we've had a couple of questions come in. I'll just answer probably the first one is for absolute clarity. If IDs are not verified by the 18th of November, so I think this is a company where there's numerous directors, probably around 7 out of the 8 directors have verified. Are you unable to submit a confirmation statement for the company in question until the final director's ID is verified? Yes, our understanding is that a confirmation statement won't be able to be filed unless you've got the codes for every director. So yes, and it will be when your next confirmation statement is due that you would need that by. That's our understanding. Perfect, thank you. And then the next question is, I think I might have answered this throughout these. I think this was a question that was probably asked before the webinar, but I've already seen the updates about the identification rules. Can directors complete this identification verification individually through the one login? Yes, you can. There's just certain ID that you need, as I said before, in order to do that. Otherwise, if you want to streamline the process for yourself, you could also consider undertaking it through an ACSP provider. So for instance, LegalVision. Then another question is key directors' responsibilities and updating company information. I think we touched on that in the presentation. This might have been a question that came in before as well. But if there's any further questions that you want specifically asked now, please do put them in the chat box now, because we still have 5 minutes or so, so I can answer any specific questions now if you like. And then another question is, what are the most important things to do as a director? So broadly, everything that we've gone through in the webinar, the main thing as a director is to make sure you're acting in accordance with your director's duties, not misusing your power, making sure that you're acting in the best interests of the company, the shareholders, all of those duties that we've gone through, making sure the company is not trading insolvent. All of those things come in terms of the role as a director. And then the next question is, what's the potential consequences if all directors do not pass through the ID process before the 18th of November? So as I said, I think in the webinar itself, if you don't pass before the 18th of November, it will just depend on where in terms of the timeline for like your confirmation statement that you need that identification by. But it's a good idea just to get that code now, because it's then you ensure that there's going to be no holdups if, for instance, you need a specific type of ID document if Companies House is requesting it. If you go through that process now, it just makes sure that you're not going to be late once you hit those deadlines that I've gone through before. And then if anyone has any other questions, please put them through. We've still got a couple of minutes, so I'll just wait a couple of minutes and see if anyone wants to add in any other questions. Okay, it looks like no other questions are coming in. But yeah, Simon, back over to you.
Thanks so much, Michaela. So yeah, that's pretty much all the time that we have for today. Obviously, thanks to everyone for joining. And obviously, thanks for all of the information, Michaela. Super informative. Sorry if we haven't answered your questions. Obviously, please, again, do not hesitate to submit your details in the survey at the end, so we can, further assist with any questions that maybe we didn't answer. And just to learn a little bit more about how we can support your business moving forward, please do not hesitate to, get that free complimentary consultation, just so we can discuss a little bit more into depth of how our membership can support your organization moving forward. And obviously, whilst this is a free webinar, we do value feedback. So please complete the 30-second survey at the end. Again, thanks to everyone for joining. Have a really great rest of the week, and we'll see you soon. Thanks a lot. Take care. Bye-bye.
Thanks.